accosting a minor for immoral purposes. There are two young children that were abused, and they're going to spend the rest of their lives in trauma therapy because of it.
I want the truth. You can't handle the truth.
And then we have a sentencing of Jonathan Nixon. All right, and we're here for sentencing on accosting, which is a 4-year felony, guidelines at 0 to 17 months.
My client pled to accosting for immoral purposes based off of pornography that had been viewed in the home. And so I believe a lot of the scoring is based off of, as much as I respect the probation officer, a lot's based off of her narrative that we don't necessarily agree with, and how the children were treated. And so pretty much every place that was scored, I have an issue with, because it wasn't based off of anything that was admitted to by my client for this charge. So the first one would be OB3, physical injury to a victim, based off of what was admitted to. There was no physical injury, so we'd ask that that one be scored as 0.
Well, I mean, when he pleads to in a couple, well, Mr. Radsman, what's your position? I think that's going to affect a lot of the OVs here. What's your thought about that argument?
Judge, I guess the behavior here, certainly there was psychological injury. I mean, our victim is in intensive counseling and will probably be so for a long time, if not for the rest of her life. I can't say there was a bodily injury requiring medical treatment. However, there was certainly phrases, certainly secondary to the psychological injury, self-harm behaviors. So.
Well, I mean, in terms of, well, the OV3, I think, is based upon the touching where the complaining witness said that it made her bleed. And the defense is saying, well, gee, but I didn't plead to that part. So what's your position with regard to that?
No, Judge, I mean, he pled to what he pled to. And I understand the other part, perhaps, to upgrade sexual conduct.
Well, I'm not sure I agree with that, Mr. Gilbert and Mr. Radsman. I mean, when Mr. Nixon pleads to accosting a minor for immoral purposes, and then, you know, he's done a bunch of different things to accost that child, and for purposes of establishing a bare factual basis for the plea, he admits to one little half piece of it. I don't think that means he's insulated from the court considering the whole conduct of accosting for immoral purposes. The sentencing offense is accosting. The sentencing offense is not showing pornography to a child. So I'm considering all of his conduct in accosting this child as for scoring purposes. So I think there is a basis for OB3 at 5 points. Any other challenges, Mr. Gilbert?
Well, yes, Your Honor. I guess then I'll take it back to the actual charging document. He wasn't charged with any type of penetration, even in the initial one. So that would be where the physical, as the court just pointed out, that's where the physical injury would be coming from. So if it wasn't even charged initially, it was charged in the second, I would still argue that OB3 should be a 0, as is OB11, which requires penetration.
Well, but that happens all the time. Somebody can be charged or convicted of an OB or of a CSC2, but if there was a penetration, I mean, that's why we score OB. That's why OB11 exists sometimes. So I guess that doesn't make a lot of sense to me either. I mean, if his conduct in accosting this child did include penetration, which it sure sounds like it did, I'd score that. Just him saying, well, I didn't admit to that part doesn't insulate him from that.
Okay, well, just so I have it on the record, Your Honor.
Sure.
So I guess I would, based off of not being charged with it and what he pled, I disagree with OB3, OB4, OB9, OB10, and OB11.
Okay.
As well as OB13.
Okay, and I would reject all those challenges.
Okay.
Mr. Radspan, any scoring challenges from people?
I know, Judge. I think it's scored appropriately.
All right, and Mr. Gilbert, anything you want to say on behalf of Mr. Nix?
Basically, Your Honor, is my client did admit some wrongdoing here. I would ask that the court follow the guideline range and sentence somewhere between 0 and 17, if that's where he falls, and not exceed the 17. All the factors, as the court has pointed out, he's received points for everything that could possibly have happened, and so that scoring range does seem appropriate to what he pled to, and considering those factors are there. So I'd ask the court to stay within the 0 to 17 and possibly consider county time. He has sat for quite a few days already before he was released on bond. Thank you.
Mr. Mixon, anything you want to tell me, sir?
I don't really have nothing to say, Your Honor.
Okay, thank you. Mr. Radsbon, any recommendations from people?
Yes, first of all, Judge, I want to make sure the guardian for the children did prepare statements dated November 12th. I want to make sure you have.
I was able to review that, yes.
Okay. She is present. She asked if she could make a statement. I don't know if it'd be anything different than what she had in writing, but I'll leave that up to the discretion of the court.
Okay, I was able to read the written statement, but if you wanted to make a statement to the court, you can certainly do so today. Just right there is fine, or you can stand at the prosecutor's table if you want, or just behind the bar, whatever you prefer.
Shaking right now. This whole situation has uprooted my whole family. When we took guardianship, we were not aware of the sexual or physical abuse of the 2 children. I want to make sure that it is on docket that there were 2 children that were abused. Why one of the children's case was dropped, I do not know. But these children are still coming forward with new information. A new 3200 CPS report was made with new information that was disclosed to the counselor. And that's going to be the case with trauma. As they get older, they get more comfortable, they feel safer, they will continue to disclose more information of the abuse. I do not agree with the plea that was offered. I don't know if you have the jurisdiction, if the court is able to reject the plea, but this goes beyond accosting a minor for immoral purposes. There are 2 young children that were abused, and they're going to spend the rest of their lives in trauma therapy because of it. Just last night, even one of them had a nightmare about John, and she came running up the stairs crying. This isn't something new. This is something we've been dealing with for 2 years. And I asked the court to not be lenient on him, because these children don't have that option. They have to spend the rest of their lives dealing with this.
Okay, thank you.
Thank you.
Mr. Radsbon, any recommendations, sir?
Your Honor, in reviewing this, I see the department recommended exceeding the guideline range, and I'm in support of that recommendation. I think this was egregious grooming behavior on the part of the defendant. I think it justifies exceeding the guideline range.
Mr. Mixon, you're 52 years old. You have 6 prior felonies. One of them is a sexual offense against minors in 1998 in Alabama. So you're a repeat sexual offender. In this case, you were grooming 2 kids and abusing one of them. You're, as I said, a repeat sexual offender. That isn't taken into account in the guidelines. And I have no authority over the charge in a case when it's lawful. So that's up to the prosecutor and the defense to sort out, through charge bargaining what the charge is. You're convicted of accosting with a 4-year statutory maximum. The most that's within my power is to sentence you to not more than 2/3 of the maximum. And that's what I'm going to do. I'm going to give you the maximum that I can because of the repeat nature of your sexual offenses against children, sir. I'm going to commit you to the Michigan Department of Corrections for not less than 32 months, no more than 4 years. You do get credit for 174 days previously served. There's $130 in crime victims assessment, $68 in state costs, and $350 in court costs.
And here we go. The complainant stated he observed the defendant inside of his property without pants and underwear on. The complainant stated he observed the defendant dry hump the air and roll around in the dirt.
I want the truth. You can't handle the truth.
Mr. McAlpin, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause.
On November 24th, 2024, the officer was dispatched to a residence in Harris County, Texas, in reference to an indecent exposure call. And upon arrival, the officer met with the complainant, who stated that he observed the defendant inside his property without pants and underwear on. The complainant stated that he observed the defendant dry hump the air and roll around on the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be open and observed his credit card missing and his in-car charger to be damaged. The defendant was the only person inside of the property at the time of discovery.
Trespass of what?
That was fled, Your Honor.
Is it house? Is it car? Did I miss something?
Your Honor, it just pled as being on the property. It doesn't specify if it was a vehicle, so the complainant just stated that the defendant was inside his property area.
Was there prior notice of him not to be there? Or, because I didn't hear you say anything about prior notice. I didn't hear anything about you saying,
Your Honor, it was just a residence, and in the case of a residence, notice is presumed, and he was.
no, we don't presume anything in the law, you know? I mean, we don't go based on hunches and read it to me again, please.
Yes, Your Honor. On November 24th, 2024, officer was dispatched to a residence in Harris County, Texas, in response to indecent exposure. The complainant stated he observed the defendant inside of his property without pants and underwear on. The complainant stated he observed the defendant dry hump the air and roll around in the dirt. The complainant also advised he observed the front driver's side door of his motor vehicle to be opened and observed the credit card missing and in-car charger to be damaged. The defendant was the only person inside of the property at the time of discovery.
Yeah, I mean, there's no prior notice that he's not supposed to be there. You didn't say anything. You didn't say anything about he's
There's
trying
no
to.
statement as to without permission. The only thing is it is a residence, a residential area, Your Honor.
All right, I'm not going to find probable cause to go forward, Mr. McAlpin, but you're on notice now. If you go back to this place, they're going to probably arrest you. Do not go back to this place. Watch out what you're doing. You're on felony deferred for a very serious crime that can give you 10 years in prison. Do you understand?
Yes, sir.
Behave yourself in the free world. And if you cannot, you're going to end up possibly 10 years. You understand?
Yes, sir, Your Honor.
Take a seat.
Thank you.
You are Alex Rojas. Mr. Rojas, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. Okay.
The complainant and the defendant are in a common law marriage, and on August 26, 2024, the officer responded to a family disturbance. The complainant and the defendant were in a verbal argument because the defendant accused her of cheating, and the defendant pushed her on the left rib area, causing her to fall and causing pain to her left rib area. The defendant then retrieved a bottle of bleach and sprayed bleach on her several items, causing it to get on her face, shirt, and right arm, causing a painful burning sensation. The defendant then pushed her once more, causing her to hit her head against the door frame, causing pain and a laceration. The defendant then bit the complainant's right arm with his teeth.
Mr. Rojas, I'm going to find that there's probable cause to go forward with your case. A protective order has been issued in this case. I would suggest that you get to know it. If you violate the protective order, it's very possible the state files an additional case against you, a violation of a protective order, and that is the capital murder of misdemeanors. You pick up a VPO, things will go sideways real quick. Do you understand? No contact means no contact in any way, and that's what I'm ordering you now. Don't be in possession of any weapons, and you shouldn't have weapons as it is. Do you understand? Mr. Rojas, heed this warning. Don't have any contact with this person. Do you understand? All right, please.
Yes, sir.
You need to understand one thing, Mr. Shelby. You don't have anyone that's going to pony up any kind of money to get you out. So when you go to jail, that's where you stay. Do you understand? Yes or no?
Yes, sir, Your Honor.
I am now ordering you to have your ankle monitor over 1% charged. And if it hits a dead battery again, so will your bond. Do you understand?
Yes, sir, Your Honor.
What did I just say?
Keep your charge.
You must charge this thing 1 hour every single day.
Yes, sir.
What did I just say?
Keep your charge every day.
No, that's not what
No,
he
it's
said.
not what I said. You have to charge your ankle monitor for 1 hour every single day.
1 hour every single day.
What happens if you don't?
I go to jail.
Amen.
Correct. I will not play this game again. 3 strikes, you're out. And I don't care who is in here arguing on your behalf. I will not play this game with you again.
Yes, sir.
Okay, Lauren.
All right, Mr. Shelby.
Thank you for watching my episode till the end. I want to say thank you to my subscribers for helping my little channel get to here. If I could, I would kiss you all passionately, but instead, I'll feed this cat some more. If you like my selection and how I edit out the boring parts, please like and subscribe and become a subscriber of mine and some very fat cats. If you would like to check out a selection of my episodes, please click on and save the playlist on screen now to your YouTube. And I'll get to feeding this cat.